morning.
How are you all doing?
Tired, exhausted.
Yeah, but you made it to a 9 o'clock class. You made it to this 9 o'clock class to study civil procedure. So many familiar faces back for more abuse from last semester in a class that you signed up for on purpose. How's everybody doing? Did you work over the summer? Yeah? Worked really hard? No? How many of you worked at a law firm over the summer? Most of you. How many of you drafted pleadings at a law firm over the summer? Or motions or anything? You drafted stuff. You actually drafted documents. You will be doing that in here. Let's talk about what, gone are the days in undergrad. You remember you would go to a class and the professor would just hand you the syllabus. Then you'd go off on your merry way, enjoy your life, frolic in the sunshine. Those days are gone. Now, you'll work, but not too hard. It's not too bad. Did you guys look at the syllabus in this class yet? Yes, everybody got that? With Blackboard, we remember Blackboard from last year? Yes, good. All right. So let's take a look at that and see what sort of horrors are going to await us this semester. The big thing that, I've talked to other practitioners in the community about the fact that I'm teaching this civil procedure class, and the universal response from everybody who's practicing law is, are you going to teach them about civil procedure? Are they going to learn anything that they're actually going to use in practice? And the answer is no. But what we're going to try to do, what I'm going to try to do in here is to get you guys thinking about how the rules of civil procedure actually apply in civil litigation. I know that many of you will not go on to be civil litigators, and I understand that, but many of you will. And be that as it may, all the rules and everything, so those of you that know that had me in legal writing, or probably anybody in legal writing last semester, all the rules that you have to live by as a lawyer are pretty much structured around the idea of a jury trial. And those jury trials happen very infrequently, but the rules of civil procedure all sort of assume that this mythical jury trial is going to happen, right? So even if you are an in-house counsel someplace, right? Even if you are general counsel to a corporation, even if you are a public defender, right? Or a prosecutor, something like that, you go into government work. A solid basis in how to do the basic passing and dribbling of the rules of civil procedure, of civil trial practice, is going to be good for you. Now, in terms of what we're doing in here, we're going to cover, if you've looked at the syllabus, you know we're going to cover basically a different topic every class or every 2 classes. And I will ask you on most days to draft something before you leave the class, okay? Including today. Today, we will actually draft a legal document that could be used in a case, a real case somewhere, right? I'll give you the scenario, I'll tell you what to draft before you go. And when you have brought it to me, to show it to me, put your initials on this little sheet right here, and you can go. Okay? Sound good? Does that all make sense? That is the key to you. And if you don't get it done, then you have to stay here, potentially all day or all week until it does get done. Just kidding, I'm not going to keep you here. I know it's 9 in the morning. Tough room. Okay. So, course learning outcomes, all the same stuff basically that you had last semester. You will be spending lots of time on motions and pleadings. Dispositive motions, what do I mean by dispositive motions? Anybody know what that is yet? If you were in my class last semester, which many of you were, of course you know what dispositive motions are. Because you were paying rapt attention and taking copious notes. What are dispositive motions? A big part of what we're going to cover this semester. Does anybody know? What does dispositive mean? That's one of those big words that people will pay you $300 an hour to know. What does dispositive mean? Come on, guys. Was Starbucks closed or what's going on? Come on, we got to wake up. I know it's the first class. 9 in the morning. What's dispositive? Yes.
Well, isn't a dispositive motion
Yeah, dispositive. Like how many of you are English majors? Yeah, break down, only one? A weird law school class. Break down the word dispositive. It disposes of the case, right? It's something that disposes of the case. So when I think about dispositive motions, and this is a word that gets used a lot, like you have to know this word, okay? If you don't know that word as you sit here today, make a note of it. I'm going to be saying it a lot. Your other professors have probably said it a lot in class. And you just sit there like, oh yeah, okay, dispositive, sure, without knowing what it means. So this is the thing that we do, right? Gloss over all these words as we're reading them without really knowing what they mean because we think we know what they mean. I think I dragged some of you through this last semester too. What does this word that you see in all kinds of cases, obviate, what does that mean? Yeah?
Doesn't it obscure it?
Not exactly. For the longest time, I thought this word meant to make something more obvious, which in fact, it's the opposite, right? To get rid of it, to obscure it. Okay, I'll go with that. Yes, give you credit for that. Good. Right? To get rid of it. But dispositive is something that disposes of a case. When I say dispositive motions on the syllabus, what am I talking about? What kind of motions could dispose of a case? Motions to dismiss. Motions for summary judgment. Good. Yeah. Motions for judgment on the pleadings, which we'll also talk about. A motion that is designed to get rid of the case. Okay? Is a dispositive motion. And that's a lot of what you do as a civil litigator. That's a big chunk of it. A big chunk of it. Who's responded to a motion for summary judgment or drafted a motion for summary judgment in here? Good. Okay. That's a dispositive motion. That's what that does. Okay? And you know that if you've worked at especially small civil law firms, that's what you spend a lot of time doing, is responding to or drafting dispositive motions. Okay, well, I'm off on a tangent there. Everybody able to get the book? I had a couple of panicked emails about that. Are we okay on that? Yes? All right, if you have trouble with that, let me know. The supplement. Is the supplement easily available to you guys? Do they give it to you along with the book and say, here's the, I think it's only an electronic supplement, right? So there's no card or anything in your book that says, here's how you get the supplement. I'll check on that. I asked Professor Cross about it over the summer, but he didn't know either. So let me check with Abramson about that and see if I can get that figured out. We're not really going to be relying on the supplement. I think I have 1 or 2 suggested readings out of the supplement for the entire semester. So not a huge deal if you can't access it, but poke around so you can get to it online. The website is just Blackboard, honor code, classroom etiquette, all that good stuff. Is anybody in here without a typing device of some kind? Without a laptop or something that you could draft up a document on in class? Anyway, if that is a problem for you, come and see me because we got to figure something out. I don't want you to be stuck writing everything by hand on a piece of lined paper. Because you will be doing drafting. Grades, 25%, showing up, not being a bonehead, 75% is your final exam. Haven't exactly decided what that's going to look like yet, but it's mostly going to be pay attention to the notes and questions and the problems that I assign you for your reading, and especially the ones that I put up here on the projector that we talk about in class, because there's a good chance that those show up in your final exam, along with a very modest drafting exercise. You might have you draft a motion or something like that. Okay? So, foundations, these are in every syllabus. And as I said, you got to show me something before you leave the class on most days. Final exam, we already covered. Now, let me ask you, because you guys are coming from different worlds, because of the way that we do civil procedure now, which is totally different from the way that we had staggered the class when I was a student. what did you guys cover last semester? I know some of you, how many of you are coming from McNeil? And then some from Abramson? All of you all coming from McNeil, and you had to buy another book, huh? Sorry. Sorry about that. I can only teach out of one. So that's a strange thing. What did you guys cover, oh gosh, did you guys cover the Erie doctrine? Did anybody cover that? Nobody got that. That's on the bar exam. What about issue preclusion? No, doesn't ring a bell. Claim preclusion? The federal rules of civil procedure? Good. All right, good. You got some of those. Okay, what about just like basic personal jurisdiction? Everybody did that, okay? Diversity jurisdiction, which we'll talk a little bit about today. Okay. Everybody got it. If I say diversity jurisdiction, we're not like, what? Okay. You got that? Okay, good. We'll figure that out as we go. The problem that I'm having with this, and I'll probably revise the syllabus at least once before the end of the semester. The problem that I'm having with this is that based on my practical experience, 15 years-ish now as a trial lawyer, the issues, like the Erie issues and the issue preclusion and claim preclusion and that kind of stuff, the stuff that pops up on the bar exam is not really the stuff that you run into in practice, okay? Surprise, there's some impractical things on the bar exam. Okay? So we will spend time with those things, but I'm not going to spend an exhaustive amount of time. I'm basically going to try to feed you the kind of information that you'll need for the bar exam, but in 15 years of practice, I don't think I've ever briefed an Erie problem. Okay? I think I might have briefed one or two issue/claim preclusion type things. If you don't know what I'm talking about, that's okay. You will by the semester. Let's see. So today, though, pleadings. This entire week and next week, pleadings. What is a pleading? What is a pleading? Who wants to tell me? Layperson's definition. Yeah.
It's a comprehensive document that recites all claims and defenses.
That's a layperson's definition?
Oh, sorry.
No, that's right. That's right. Well, give it to me in plain English, though.
So a person brings a complaint against another person, and then the other person can respond to that, and then they can do that process again.
Mm-hmm. Okay. The first thing, or the first things that get filed in a civil case. Okay? Think of it that way. That's what pleadings are. It's the first things that get filed in a civil case, basically, right? Complaints, answers, petitions and responses. Has anybody ever drafted a petition for anything? Yeah, what was it for? Dissolution of marriage. That's a really common one. Petition for dissolution of marriage. First thing that happens in dissolution of marriage act, right? A divorce case. Somebody, yeah, Brittany.
It was a petition to vacate so like an expungement. But
Yeah.
Yeah.
Okay, right. So think about an expungement. How many of you work with expungements or know what that is at least, right? So somebody's got a criminal record, they have a criminal case somewhere back in the past, and they want to file, that case is over, right? Now they want to file an expungement. First thing they file with that court is the petition to have the charges expunged. Complaints. That's the big thing we're going to be dealing with the next two classes. What are complaints? Who has drafted a complaint? Wow, really? Cool. All right. You guys got some good practical experience already. All right. What is a complaint? Who does it speak to? Sorry? It speaks to the plaintiff?
Speaks to, do you mean like who is it like directed towards?
Yes. When you write a complaint, who is that directed at? Who is supposed to be, who do you expect is going to be reading it? Who's your audience? Sorry?
The court and the
Yes, the court, right, and the defendant. The plaintiff is the drafter. Well, the plaintiff's lawyer is the drafter, hopefully, right? Or else we get some crazy pro se complaint, which we might look at. Those are fine. But the plaintiff is the drafter, right? It's directed to the defendant. I think I'm jumping ahead of stuff here. It's directed to the defendant and to the court, okay? An answer. What is an answer? Also a pleading. Who writes the answer?
Defendant.
Yeah.
The defendant writes the answer?
The defendant probably writes the answer. The defendant's lawyer writes the answer. Okay? Got a whole section on answers. If you're sitting there going, this is pretty simple stuff. It is, right? It is. It's fairly simple. But then you read the rules of civil procedure, and you're like, oh my God, what do I do? How do I do this? Right? Can you read the rules of civil procedure and know how to draft a complaint and an answer? If you can, you're a very good critical reader. A very good inferential reader. Better than me, right? What's the difference between a pleading and a motion? Yeah.
A pleading is more comprehensive for the case as a whole, where a motion is more directed at one specific issue.
Yeah, what are you trying to do with a motion? Who's drafted a motion? Good. Give me an example of a motion that you drafted, somebody that had your hand up. Yeah.
Motion to clarify arbitration award.
Motion to clarify arbitration award. You drafted that? Good job. And what were you trying to get the court to do? And I assume it was drafted at a court, or was it drafted to an arbitrator?
It was directed to the court to pretty much, because the employer in the case was refusing to pay back the back pay, the wages, because they said the arbitrator didn't have jurisdiction anymore, so he had to pretty much go through the courts to get it remanded back to the arbitrator to have him have the exact number computed and everything. So.
Right. If you're asking for something very specific, we're not trying to start a new case. I'm not trying to dispose of a case. I'm not answering allegations against me. I want this one thing to happen in the context of the overall case. That's a motion. Okay? Less comprehensive, as you have already said, than a pleading. Another example of a motion. Who else has filed a motion? Yes, Seth.
Motion for preliminary injunction.
Motion for preliminary injunction. Yeah. And what's a preliminary injunction?
Well, we were asking the court to prevent the defendant from having business litigation suit.
Yeah. So you're saying, defendant, stop doing the thing that you're doing. Court, order the defendant to stop doing the thing that they are doing. Okay? But that's in the context of an overall suit. You file the pleadings, the suit has happened, the action has happened, it's already in full swing, then you file your motion for preliminary injunction or your motion for whatever it is. And as you know, if you've been in my class and done a little bit of this motion practice, those motions can be pretty much for whatever you want, right? Not so with pleadings. With pleadings, we have certain parameters that we have to obey. What are those parameters? Well, that's why you're here. We'll talk about it the rest of the class and on Friday. But what is the very first thing that gets filed in a federal civil case? Who knows? What's the first thing? Yeah. Complaint? Who else says complaint? Complaint? Okay. Anything else? Wrong, you're totally wrong. It's a trick question, see? Actually, the first thing, hey, you're right, you're basically right. But what goes along with it is, yes, go ahead. This civil cover sheet, right? To accept the license every single time. Where did it go? Here we go. This civil cover sheet, right? In the federal courts. Now, is it annoyingly different in every single court that you're going to practice in? Yes. Yes. It's mostly uniform in the federal system, okay? Mostly uniform in the federal system. But in the state courts, anything goes. You got one of these that you file in the state court? No, not really. You just file your complaint and your summonses, which we'll talk about too. And that's it. But to initiate a civil case in the federal court, you've got this simple one-pager that you can easily Google and get from the court's website, the civil cover sheet. Okay? And technology is such, in the federal system, not the state system yet, but technology is such that you can actually fill out these forms online, right? I think. There's fields there that you can fill out. Basis of jurisdiction, you have to know who the plaintiffs are, you have to know who the defendant is, you have to know the county of residence of each one of these, okay? Attorneys, basis of jurisdiction, and this is where you get into last semester stuff, right? Federal question jurisdiction, everybody knows what that is, right? Good. Diversity jurisdiction. And then they ask for the citizenship of principal parties. Principal is AL. Remember that, very important. And why do we need to know the citizenship of the principal parties? Yes?
Because it helps determine whether there's diversity jurisdiction or not.
Yeah, you have to determine whether or not there really is complete diversity between the parties. And remember, there has to be complete diversity between the parties to obtain diversity jurisdiction. You all remember that, right? I'm just trying to warm that up a little bit. Diversity jurisdiction is the thing that you'll deal with in practice, at least in my experience. If you have a regular civil practice, you will deal in some way with diversity jurisdiction. If you don't know anything about diversity jurisdiction and you're just trying to blunder through a civil practice, it can be problematic. With diversity jurisdiction, that gives you the ability to get in or stay out of courts that you might want to be in or out of, if that makes sense. And that can be very powerful and very good for your client, as we will see in the next 80 to 90 slides. Okay, that's the civil cover sheet. But then you file a complaint. We've already said, what does the complaint say? Who did it say it to? You're saying to, the plaintiff is saying to the defendant, here's all the stuff that you did wrong, and here's what you owe me. Okay, simple as that. But how do you know what to put in there? How do you know? How would you go about drafting a complaint? You go out and hang a shingle. You started this new law firm. You're very excited because you couldn't get a job after law school, and so you're just like, I'm just going to hang a shingle and do a civil law practice because why not? I know really dumb people who do it. And a client comes to you and says, I've been wronged. I have been aggrieved, and I demand recompense. And so you have to draft a complaint and get that into court on behalf of your client. How do you go about doing it? Well, yeah, go ahead.
Well,
It was a rhetorical question, but I mean, if you have an answer, right?
Well, first of all, you need to know the main facts about what happened. What exactly was is he saying was the wrong?
Yes. Yeah. Yeah, it would be good to have some factual information in that complaint. We'll get there. We'll get there. All right. But it can be kind of a daunting and intimidating exercise to go, I represent this person and I gotta draft this complaint, and how do I know I've got all the right stuff in there? Okay, so let's talk about that. First, federal rule, number 10. Federal rule number 10. Not very helpful. But it does give you the form of pleadings. And it's like, if you flip through, many lawyers that have been in practice for a long time don't do this, right? But flip through the rules and look at the title of the rules. And And sometimes that's very helpful. So if you come across a rule that is called form of pleadings and you're trying to figure out what the form of your pleading should be, maybe there's some help there. Yes?
Did you by chance turn on these little side things? I can't really see the.
I don't know. Is that not on? Yeah, that's tiny print, sorry. Oh. Did it work?
Yeah, it's not anymore.
Oh, it's, okay.
Yeah, okay, good. But anyway, all this is the text of Rule 10. Okay, so if you can't see it, just pull up Rule 10. Simple as that. But it tells you that you've got to put the names of the parties. Okay, well, that makes sense. Paragraphs, separate statements. If you've ever looked at a complaint before, you know you have 1, 2, 3, 4, 5, 6, 7, right? Numbered paragraphs that say different things. The formatting of the thing isn't so much the issue, it's the content, right? But know that you've got to have numbered paragraphs. So when you get down to drafting a complaint, which will be very soon, hint, hint, okay, know that that's at least something you got to have in there. The names of the parties and your numbered paragraphs. Adoption by reference and exhibits, well, we won't be doing any of that, but you can, it's oftentimes not necessary, but you can include exhibits with your complaint or with your plea. Most of the time not necessary, but who is a potential third audience that you're writing to? If you're the plaintiff, put your plaintiff's hat on for a minute. And think about this. You file a complaint. It goes to the judge, it goes to the defendants, and who else has access to it? In most cases. Sorry? Thought I heard it. The public. Yeah, the public has access to it. So if you think you're filing something that is of public interest, and trust me, you never know when you're going to end up on the news with your client, then might you want to attach more stuff to your complaint? Might you want to attach more proof that things are the way that your plaintiff says they are? Maybe. Maybe. This just says you can do that. But this is very rudimentary, very basic stuff. It doesn't really tell you a whole lot about how to draft a complaint. Well, all right. So, Federal Rule 8. Aha. That's a little more helpful. But not great. Not great. Right? Pleading that states a claim for relief. What does a claim for relief mean in this context? Yeah. Give me an example of a claim for relief. What does that mean in this rule? What does it mean to say that I'm making a claim for relief, Ryan?
The court saying that the defendant has to pay the plaintiff.
Yeah. These are the facts in the law that entitle me to relief, that entitle me to compensation, or entitle me to something from the defendant, right? Sometimes, as in Seth's example, you're asking that the defendant change their behavior in some way. Stop doing a thing, right? Or do something else. Most of the time in civil litigation, a claim for relief is saying, here is the law, here are the facts that entitle me to get money from this defendant. Okay. Everybody gets that, right? Simple. A short and plain statement of the claim showing that the pleader is entitled to relief. Well, what could be more simple than that? A short and plain statement. Great. So all of my complaints can just be one-pagers, short and plain, very simple, bare bones, little statements saying, I am entitled to relief. I am entitled to this defendant paying me some money or doing something different or doing something. Okay. And those of you that have done the reading, is it that simple? course not. Or you wouldn't get paid $300 an hour. Right? Short and plain statement of the claim showing that the pleader is entitled to relief and a demand for the relief sought. What is a demand for relief? What is a demand for relief? Yeah.
So then what you're asking for.
It's what you're asking for from the defendant, basically.
Oh.
Yeah, but yes, you're right. You're asking the court to order the defendant to do a thing. Pay you money or do something else. Usually pay you money, right? That's your demand for relief. We'll look at examples of all this stuff. Have no fear. Have a little fear. And what is relief in the alternative that we see there in paragraph 3? A demand for relief, which may include relief in the alternative. Yes?
If the court doesn't think that the original demand, the original type of relief sought is viable, then there's a kind of a second option.
I think you've got it. Yes. So if you're the plaintiff and you're pleading, you're asking for relief in the alternative. Okay? This is within your province. Remember, this is a rule directed to you, the plaintiff's attorney. How do you ask for something in the alternative? Can somebody give me an example of that? Relief in the alternative? Yeah.
Like if you're doing like you're going to support emotional stress or something, and you're going through like your main argument, and you're like in the alternative, and without waiving like the fine previous argument, even if you don't agree with that, you should give me relief with this.
Okay. Yeah. You've drafted dispositive motions or responses, right? Yeah. You can tell. It just had that sort of war zone look. I've really been through it with these dispositive motions. Yeah. Yeah. So for example, I think I'll get it. When you're asking for relief in the alternative, let's see. A, D, and E speaks to these two. Okay. Well, I'll come back to this. A, B, and C, just real quick, we don't care about in the context of talking about complaints and why. You know this because you've read the rules. And you memorized them. No, you haven't memorized them. Right. B and C, what do B and C deal with?
For the other team.
They're for the other team, right? They deal with the answer, okay? They deal with responses to the initial pleading. The responses to the complaint, the answer to it. So we're not worried about those yet. D and E, again, we have this reiteration of pleading needs to be concise and direct. Kind of, right? If you read Iqbal, you know that there's an asterisk about that. Alternative statements of the claim or defense. Okay. Well, first, paragraph 1, no technical form is required. Again, we'll get to Iqbal. It's kind of true and kind of not true. Alternatively or hypothetically, you may make your claims alternatively or hypothetically. Okay. What does that mean? Claims may be, separate claims or defenses may be made regardless of consistency. What does that mean? Well, think about the difference between intentional torts and negligent torts. You draft a claim for battery, okay? Saying, this person intentionally ran me over with their car, okay? That's battery. That's an intentional tort. Okay? If you were to plead that case in the alternative, what would your alternative claim be? You don't want a complaint out there that's just battery. You don't want a claim out there that just hinges on that intentional tort being made. What else do you want in that complaint? Negligence. Is it possible to have acted intentionally and negligently at the same time? No. Right? Can't do that. But you're saying you can make both claims in the context of a complaint? Yes. That's what this rule allows you to do. And you should do it. You are drafting a complaint, you should do that. You should lob everything out there that you can possibly lob because you don't know what's going to survive by the end of your case, which could be very short, and what's not going to survive, right? Would it be possible, and I'm jumping way ahead here, would it be possible for me to file a complaint for battery in that context, and then battery only, and then I get hit the next day with a motion for summary judgment that says clearly this wasn't intentional? Is it possible for the defendant to file something like that? Sure, it's possible. Sure. Will people file dumb shit like that all the time? Yes. Okay. But that's an example of alternative. By the way, I don't know if you covered this last semester, but every state has its own little pet version of all these rules. Right? So we're talking about the federal rules mostly in here, but I'm going to refer to those Kentucky rules every now and then because guess what? Many of you will go to a state practice where you won't touch the federal courts ever in your lives. And be thankful for that. But what is the counterpart in the Kentucky Civil Rules of Procedure to Federal Rule 8A? Yes?
Civil Rule 8.01.
That's what it is. You need to look it up in Lexis or Westlaw. That's what you get. KYCR 8.01. Okay. Bonus rounds, if you cite this in Kentucky courts, you just cite CR 8. Okay? That's how that cite goes. Very soothing sound. All right. Now, if you look at, actually, let's pull it up. Here's sound. Here's some time. Let's pull that up. Last law. Now watch, it won't come up. CR 8.1. And then in the West, I think you got to scroll down here. You get some cases. If you go to statutes and court rules, this is a court rule. CR 8.01, there it is. My question is simply this, and I'll move on. Is this the same thing as Federal Rule 8A? This is a simple question. Well, is it the same as 8A or not?
Pretty close.
Really? I'm sure. Yes.
Yes.
In essence, right, this thing here is the same, but then you got this thing down here. It's still part of CR 8.01. It talks about what you can do in terms of putting liquidated and unliquidated damages in your complaint. Does anybody have any idea? Do you remember from contracts, did you cover in contracts the idea of liquidated damages, unliquidated damages? Okay, that's what this speaks to. And the thing to remember is that in Kentucky courts, you don't put the amount that you're seeking from the defendant into your complaint. Okay, that's the thing to remember. That's the basic rule of thumb. In the federal courts, you can. You don't have to. All right. So if these rules aren't super helpful, how do you know how to draft a complaint? Well, there's case law, I suppose, that interprets those rules, which we'll get to. But here, for your reference, in case you ever need it, before the end of the week, let's say. Here's the anatomy of a typical complaint. Okay. Style or heading. You drafted a complaint, you probably know about all this stuff already. Names of the parties, the file number, all that stuff. Okay. You don't put the right case number on your complaint. So you can't put a case number on a complaint. If you don't put the right case number on a pleading, like an answer, that's a problem. But when you draft a complaint, you're not going to have the actual case number on there because in most cases you don't have a case number. Okay? So you leave that blank and the clerk fills it in. But you do have the names of the parties, hopefully. Sometimes you don't even have that. If you have unknown defendant, that's also a possibility. It's too far down the rabbit hole. We'll talk about it later. Introduction. Many examples that you look at, many complaint examples that you look at will not have an introduction or a preliminary statement. Fine. As we've seen, the rules don't require it. But good practice, which you don't know until you've been in practice for a while, good practice dictates that you put something in there to let the court know this is this type of action. This is an action for battery. This is a civil rights action. This is a petition for dissolution of marriage. Okay? Tell the court what it's about. Description of the parties, self-explanatory. Statement of jurisdiction. I maintain that in just about every document you ever file with a court ever, you need to reassure them that they have jurisdiction to do what you're asking them to do. Okay? That's especially true of initial pleas. What is the authority under which you are able to get this thing into the court in the first place? Is it statutory authority? Is it common law? What allows you to do that? Here's a fun thing. Think ahead to Iqbal. Read the Iqbal case, right? Of course, because it's still early in the semester. But everybody read Iqbal. And Iqbal is what kind of action? Does anybody know? It doesn't really say in your reading. It's excellent. Yes?
Is it civil rights?
It's a civil rights action. How did they get into the court?
Constitutional question.
Well, it's a constitutional issue. But don't go thinking, the reason why I bring this up is, you go into a plaintiff's practice, you have an aggrieved plaintiff that comes into your office, says, I really want you to file a complaint. I think my constitutional rights have been violated. You don't get to just file a complaint that says their constitutional rights have been violated. You have to have a vehicle to get that case into court in the first place. The Constitution itself says nothing about you get to maintain an action in the courts, in Article 3 courts, for violations of this document. Right? You don't get to do that. You have to have some kind of statutory authority or other authority to get there. And the way they get there in the Iqbal case is a curious thing, which to really learn about that, you have to take my civil rights course. But anyway, telling the court what your vehicle is for getting there, that's part of your statement of jurisdiction. It's not just, this is based on diversity jurisdiction, or this is a federal question thing, or this is a maritime action. It's, here's the vehicle that I'm bringing these claims through. If it's the common law, fine. It essentially is an Iqbal. Right. Facts, statement of facts, claims, you usually have those separated out from your facts, although you will see all kinds of different things in practice. But usually there's a big section about here are the facts, and then there's usually a section that says count 1, battery, count 2, negligence, count 3, intentional infliction of emotional distress, something like that. Those are your claims. Prayer for relief, what is a prayer for relief?
What you're asking.
Court, make the defendant do this. Good luck. Give me money. Make the defendant stop doing the thing. Right? Give me a jury trial. That's your jury demand. Signature block, important. If you leave that off, it's a violation of Rule 11. Verification. Did you guys cover any of Rule 11 last semester? Anybody? Yes? Good. You didn't get most of that in your ethics class. But that's a big part of Rule 11 too. You've got to sign all your stuff, all your motions, all your pleadings, all your everything. You've got to sign it. And the verification form. What's a verification form? You don't have to have this. But again, much of this stuff you don't have to have. You've read the rules. So technically under the rules, you don't have to have an introduction. You don't have to have much of this stuff. What's a verification form? Has anybody ever done one of those? Yeah.
Isn't the verification form like, does it have to be like notarized?
Yes, it's basically a notarized signature that you append to the end of the complaint that basically makes the complaint have the effect of being your client's testimony, sworn testimony. Does that make sense? And why would you do that?
Because it's basically swearing that all the facts that they've given are true and all that they're claiming has happened is true.
Yes, and remember, this is your client doing it, okay? If you're representing the plaintiff, this is your client saying, okay, all the stuff, I've read over all this stuff, and all the facts that are in there, I swear all those facts are true. Right? Why would you do that as a plaintiff's attorney? Do plaintiffs sometimes lie to you? We'll find out. But you need to protect your own license, right? The first thing is that license, protect your license. Okay? And verification forms are a good way to do that. Let's look at some examples of this. Your textbook on page 334 has a pretty good example of what one of these things ought to look like. There you go. The heading, the names of the parties, the civil action number, which I don't know how you get that when you first file a complaint, but that's okay. Complaint, it's nice and neat, right? Everybody see that on 334? Parties. 1, plaintiff. 2, defendant. Jurisdiction. 3, subject matter jurisdiction pursuant to 1338 and 1367 rather. And why? It's not just a simple statement of this is good practice. Not necessary practice, but it's good practice. You've quoted your jurisdiction statutes. You also say first and second claims arise under a federal statute. And since those claims arise under a federal statute, you have federal question jurisdiction, right? Makes sense? Your claim for relief arises under state law. Supplemental jurisdiction. You guys did supplemental jurisdiction too, right? Mm-hmm. If there's any of this that you feel totally lost on, talk to me after class. Factual background. Again, 1 fact per paragraph. We'll talk about why that's important soon. Okay. First claim for relief, copyright infringement. Second claim for relief, violation of attribution right. I've never filed something like this ever in my life, but conversion. That sounds a little more familiar. So here are your 2 federal counts. Here's a common law state claim. The court gets to exercise supplemental jurisdiction. Signature block, demand for jury trial. You know, and your book has a note about this. I've never seen it in my life, I don't think. And it's not common practice in Kentucky or Indiana that I'm aware of to have 2 separate signature blocks there, just to curiosity. Okay. Most all complaints that I've ever seen have just the 1 signature block at the end. It doesn't matter. You want to sign it twice? Go ahead. Sign it twice.
Well, didn't the book say because the jury demand was needed?
Yeah. No, I mean, I get it. I get what the rationale is for it, but I'm just telling you, I don't see it in practice. A couple more, one from Ohio. Right? Again, preliminary statement, same thing as introduction. Gives you, sorry, you get an F for today, it's fine. This is all that the heading tells you where the court, what court you're filing in. Case number is blank, of course, because they don't know what the case number is yet. They're just filing a complaint. All this gobbledygook is specific to civil rights cases. Really, you just need defendant name and address for service of process, which will also come. Preliminary statement, parties, who are they, what are they doing here, what's their role in this whole thing, statement of facts. Okay? Lots and lots of facts. Why do we have lots and lots of facts? Because of Twombly and Iqbal. Okay? But also because complaints like this are often a matter of public consumption. And again, you may not just be speaking to the judge and the defendant in these complaints, and you never know who's going to pick it up and say, here's what the plaintiff is alleging in this case. First cause of action, excessive force. One simple little paragraph. Would I have drafted it that way? Maybe, maybe not. But you can see that they're clearly broken out by claim, right? Makes me a little uncomfortable to have only one paragraph under each one of those, but that's okay. Jury demand, plaintiff's request of jury trial, and all claims travel to a jury. Simple as that. Easy, right? Prayer for relief, compensatory damages, punitive damages, costs, prejudgment interest, such other and further relief. No. And then there's your signature block. Compensatory damages and punitive damages, if you don't know what that stuff is yet, or whether you should be pleading, I imagine you probably know what it is by now if you sat through torts. But if you are not sure whether and how to include this in a pleading, we'll get there. Basically, what I can tell you is the simplest thing to do is to put it all in there if you're not sure. Okay? Put it all in there if you're not sure when you're drafting the complaint. It's better to draft too much than too little, because the defendant will tell you if you're wrong. And sometimes they'll tell you you're wrong even if you're not wrong. Okay? But compensatory damages is something you typically ask for. In most cases, you'd be asking for punitive damages as well. Okay? Doesn't mean you'll get it. Attorney's fees, also something very common to ask for. Costs, et cetera, et cetera. Okay? Questions about any of that? No? That's the anatomy of a typical complaint. We'll skip over the other one. We got it maybe on Friday. So notes and questions. The first one talks about merging the two separate documents into one, the jury demand along with the complaint. And it says here too that this is your option as a plaintiff's attorney, the plaintiff, to ask for a jury trial or not. Who can think of a reason why you might not want a jury trial? Why would you ever not ask for one? Yes.
If your plaintiff is not a good, they're not like a good person.
Yeah.
Or have some,
They're not a good person.
yeah.
Then you should decline representation. But sometimes you can't do that. Yes.
Actually kind of thinking back off of her, if they already have if what they do somehow has a bad name within the community already, then they might not be seen in favorable light by the jury already.
Right. You're worried about the jury being prejudiced against your client. That's one reason. Yeah. Anything else? You had your hand up,
Seeking only equitable relief.
seeking equitable, yeah. You would not, if you're getting relief as a matter of law, and that's not something that a jury can award to you. We don't need to go down that rabbit hole, but you're right. Anything else? Yeah.
If it's highly technical, like specifically I'm thinking about like patent litigation, sometimes getting that across to a jury.
Getting it across to me, that's totally over my head. But yeah, I think that's right. If you think it's going to be too complex for a jury to really get, But you guys are missing a big one. What's a big reason why you would opt for a bench trial as opposed to a jury trial? Yes.
Time and money.
Well, time and money. That's a good one too. Yeah. Yeah, time and money. It takes a lot longer to try a case in front of a jury than it does in front of a judge. Let me put it this way. Why might you want a jury instead of the judge? Yeah.
Better chance to get a majority in civil case.
Yeah, a better chance to get a majority, a better chance to, go ahead.
You could win a bigger settlement.
You could win a bigger verdict. You can get a bigger verdict out of a jury than out of the judge potentially, but all that comes down to what? Know thy judge, right? Know thy judge. So the biggest reason that you might want a bench trial instead of a jury trial is because you think you can get a better deal out of this judge. Okay? So if you have a judge that you're pretty sure is going to be predisposed to rule in your favor, and sometimes you know and sometimes you don't know. If you don't know, probably better off to go with a jury. Right? Which is always a spin of the roulette wheel. But you got to know something about the judge that you're practicing in front of. And that's not important just for bench trials and jury trial distinctions, but also for the Iqbal stuff that we'll talk about. Okay, and sometimes you'll see also these in re proceedings, habeas corpus actions, bankruptcy actions, certain domestic relations things. What else did I put on here? Land proceedings, right? In re Galt is a habeas corpus case. In re annexation of 466 acres of land is an example of a real case name. It's goofy sounding, but you may have seen something like that in property classes. In re Washington Mutual, probably bankruptcy, right? You can sort of infer what these are based on the news. So when you see that stuff, sometimes you'll have to draft a petition like that. Okay. Rule 10 says that the paragraphs in the complaint have to be numbered. And you want to keep those allegations in each paragraph as discrete as possible, right? You want to keep them as limited as possible. Why? Why not just say, paragraph 1. Plaintiff was struck by a car heading north, driven by defendant with a passenger named Jake, and I should get money. Okay. Why not? Why not just do a complaint like that? Good drafting? Good drafting. Can barely even read it. Look at it. Why not? I submit to you that you ought to break this up as small as you can possibly do it. Plaintiff was struck by a car. Okay? The car was heading north. The car was driven by Jake. Or no, passenger's Jake. Sorry, I don't even know my own case. Passenger's Jake. Right? I should get money. Break all that stuff up. Something like that, 5, 6, 7 paragraphs. Why? What happens after you file the complaint? Put your plaintiff's attorney hat on. What happens after you file the complaint? Morgan.
I know, like, at least in the answer, whenever they admit or deny, like, certain facts, it makes it easier to know exactly what you're going to dispute you on.
That's exactly right. That's exactly right. If I am the defendant, put your defendant hat on. If I'm the defendant and I have to answer something like this, I'm going to say, defendant does not have sufficient information to confirm or deny all of these insane allegations. Therefore, they are denied. Right? And that's all you get. But if you break them up, in the answer, you might see, plaintiff was struck by a car. Admit. Heading north. Admit. Driven by defendant. Admit. With a passenger named Jake. Deny. I should get money denied, right? So you can start to break down what you agree on and what you don't agree on. As a plaintiff's attorney, sometimes there's little nuggets of joy lurking in what they admit to, okay? Incorporating earlier statements by reference. Okay, look back at your complaint on 334, and you'll see, look under first claim for relief. You see where I am? Plaintiff readopts and I'll put it up there. Look under your first claim. Or under every claim. Plaintiff readopts and realleges the allegations set out in paragraphs 1 and 12 of his complaint. Okay. Do you have to do that under the rules? No. But you should. Okay? You should. Why? Because as a plaintiff's attorney, you never know what you're going to get dispositive motions over. You get lots of them all the time. And if you ever get somebody coming and saying that this claim doesn't adequately tie the facts to the law, you can say, but Judge, I reincorporated all the allegations that I made above into this claim. Okay? It's a legal fiction, and it sounds silly, but it can make the difference in whether you have a claim get tossed or not. Okay? So incorporate that into your practice. Those of you who are planning on drafting lots of complaints, trust me, you never know what you'll end up doing. That's also why people hate lawyers. Inserting seemingly unnecessary legalese like that into things, and getting your case tossed out because you didn't have that in there. Pretty annoying. Okay. This is just what I've been talking about the whole time. All those pieces of the complaint that we looked at before, they're not necessarily required. But you get to make an impression on the defendant and defense counsel and the court. So don't just slop down whatever, even if you think you can get it by that judge. Okay? Your reputation is the only thing you get to control. So go and look at other complaints before you draft your complaint. Okay? See what standard practice looks like. See what good practice looks like. Look at pleadings that have been drafted by practitioners that you feel like know what they're doing. This is a good rule of thumb for just about anything. Because not only is your reputation at stake, but you never know when the court is just going to have it in for you and is going to want to toss your complaint out, okay? As we see in Iqbal. Very quickly, nutshell, layperson synopsis, what happens in Iqbal? Who has not read Iqbal? Liars. What happens? Go ahead.
Okay, so Iqbal was arrested and detained after the September 11 events as basically a person of interest, of high interest, and they locked him down in a harsh facility, and he's suing basically saying that he was targeted because of his race and his religion, and he's saying that Mueller and Ashcroft, the Attorney General and the FBI Director, were the cause of this.
The Robert Mueller. It is the Robert Mueller. Imagine him doing such a thing. So yeah, that's right. And what does the court say is wrong with the plaintiff's complaint? Let's see if we can motor through this quick.
He sort of like didn't say that they directly was the cause of him being detained. It was kind of like, I'm trying to figure out the word for it. It was kind of like an assumption, like he wanted the court to assume that happened, and he had no facts to back it up.
That's right, yeah. So what did the trial court say? What was the standard that was used by the trial court in this case? How did the trial court look at it? The trunk work does what to the component? Trunk work thumbs up or trunk work thumbs down? Thumbs up, yes. Okay. Trunk work lets it go. All right, go back and read Iqbal again. Go back and read Iqbal again. We're going to pick that up next week because this is a super important case, right? Really important. Really important. Especially if you're going to have a plaintiff's practice. Because this has now changed everything. This wasn't the case when I was a student. Okay? This has changed everything for everybody. So if you read Iqbal and you're sort of like, yeah, okay, that's fine, whatever. Read it again. Okay? Read it again. It's important. Let's jump ahead to our example scenario. We'll look at the dog picture next time. Example scenario. Here it is. I want you to fill out that civil cover sheet that we looked at just a few minutes ago in class based upon this scenario. Okay? Can you do it in 10 minutes? Or less than 10 minutes? 8 minutes? If not, you live here. Pull up that civil cover sheet. It's very simple. It's easier than you think it is. Fill it in based upon this scenario. Can everybody see it okay? Do I need to make the text bigger for Friday? Make it bigger. I don't know if I can do it now. Oh. Maybe it was where. All right. Yes. Yes. And I have conveniently situated office hours for an hour and a half or 2 hours or something like that. So, yeah, don't catch me then.
Are we the attorney?
You are the plaintiff's attorney. I thought I'd slip that in. Sorry. I have a different draft of this that I didn't say. Sorry. So yeah, you represent the court. I think that's the only thing I left out. If you didn't represent the plaintiff, you would not be filling out a civil cover sheet. So we're in plaintiff world this week. Next week we'll be in defendant world. I feel like you got it enough up to the point of an educated guess and bring it to them.
Where's the bar located?
What?
You got a dram shop case here too.
Don't make it more complicated. It's just Hatfield, McCoy versus Hatfield. How are you all doing?
Tired.
Yeah?
Where's the bar located? Don't make it more complicated.
It's just Hatfield, McCoy versus Hatfield.
How are you all? How are you all doing? How are you all doing?
Tired, exhausted.
Yeah, but you